Welcome to this video series on the making of international in Korea. We'll begin in this week of videos with description and explanation of the core principles and practices of international law and discuss the primary sources of international law in Korea, such as law of the sea. First, let me touch upon the law of the sea in historical context and interest in the law of the sea of Korea. The sea plays an important role for South Korea's economy and security, and thus making good order at sea is a vital priority for the country. Of particular economic concern are issues such as piracy and armed robbery against ships and depletion of the fish stocks. South Korea has joined various bilateral, regional, and international cooperation agreements to address these issues. Moreover, South Korea has territorial dispute with Japan over Dokdo and Takeshima, and with China over many fisheries resources, which has so far led to little progress in maritime boundary delimitation negotiations between South Korea and these two countries. In terms of security, South Korea is technically still at war with North Korea, since hostilities during the Korean War were only halted by an armistice agreement in 1953. In particular, the issues of North Korea's nuclear weapons program, as well as the unresolved dispute over sea boundaries between the two countries in the West Sea, present serious challenges to peace and stability on the Korean Peninsula. After naval skirmishes in the West Sea in the 1999, 2002, and 2009, the tensions have escalated recently following the sinking of a South Korean Navy corvette, the Cheonan, in March 2010. With more than 99% of South Korean trade transported by sea, the South Korean economies depend on the global sea lanes of communication. Furthermore, as a country does not have domestic production of oil, South Korea is dependent on oil imports, 80% of which is transported from the Middle East through two of the world's major oil transit choke points, the Strait of Hormuz and the Strait of Singapore and Malacca. Any disruption of vessels carrying oil to South Korea through these sea lane of communication will have a potentially devastating effect on the Korean economy. At present, the biggest threat to trade and energy flow seems to be the piracy and armed robbery against ships. The South Korea is actively engaged in regional and international efforts aimed at combating this problem. The Korean Peninsula has traditionally been blessed with an abundance of rich fishing ground, created in part by the mixing of warm and cold ocean currents and the particular geography of the Korean coastline. In recent years, however, fish stocks have declined considerably, with the total stocks in 2015 projected to be only 39% of the levels in 1980. The drastic decrease is caused by various reasons, including overfishing, pollution, and climate change. Such depletion of resources not only challenges the South Korean fisheries industry, but also pose a serious threat to food security and access to seafood for future generations. While South Korea has implemented measures to achieve a sustainable use of fisheries resources, such as a total allowable catch system, the depletion of fish stock is a problem that being shared by all countries in the region, and therefore require regional cooperation. South Korea has signed bilateral fisheries agreement with Japan and China, determining, for example, quotas on each country's allowable catch in the other country's waters. These agreements, however, do not include provisions for a joint fisheries management system, which would be essential to effectively deal with the rapid depletion of fish stocks in Northeast Asia. Let me touch upon the Korean position at the third conference on the law of the sea. The third conference on the law of the sea was held amidst raising tensions between the maritime powers, advocating to maintain traditional narrow territorial sea, and the newly independent state in Asia and Africa, hoping for reform of the international maritime regime in favor of a wide high seas. During this conference, South Korea generally agreed with other Asian and African states. In an era where the country will heavily depends on the United States in politics and economy and national security, this stance can be assessed as the South Koreans, the government's own initiative for the country's rights and interests in the sea. The Korean government's core concerns during the conference are listed below. Unlike the 1958 Geneva Convention on the Law of the Sea, where the Korean government did not give a definite opinion as to the contention of the scope of territorial sea, either 3 nautical mile, 6 nautical mile, or the 12 nautical mile, they were in favor of the 12 nautical mile during the conference. Although the Korean government did not agree with the United States back in 1958 as to the notion of limiting coastal state jurisdictional capacity, the government viewed the pushing for 12 nautical mile to be too progressive. In light of the North and South military conflicts and armistice, South Korea was in favor of prior notification of innocent passage of foreign warship and the government ships operated for non-commercial purposes in the territorial sea. The Korean government's proposition for prior notification or prior approval, however, was rejected during the 1958 Geneva Conventions. As regard to the right of passage in international trade, the South Korean government advocated for innocent passage of warships, and government ships operated for non-government purposes, but rejected right of passage through the airspace and supported the reinforcement of coastal state right to regulate the pollution. This was also in light of the passage issues occurring in the Strait of Korea and the Jeju Strait. Regarding the limitation of the territorial sea, the Korean government was in favor of a median line. However, still between the Korean and Chinese continental shelf and the EEZ, a median line would benefit Korea because the nation had already designated joint development zone with Japan. Using the natural prolongation of the land territory, Korea was careful in making its position. Nevertheless, Korean government agreed that a compulsory dispute resolution measure is necessary for peaceful resolution of conflicts arising out of determining the delimitation of the EEZ and continental shelf. As regards to the marine science research, the interests of developed states were toward claiming freedom of research, while developing states sought prior consent of a coastal state. Korea took the side of the latter. Finally, Korea was in favor of adopting a compulsory conflict resolution measure for the peaceful resolution of all maritime conflicts. Since its ratification of the UNCLOS in 1996, the Maritime Order of Korea has also been reorganized to comply with the same. The Territorial Sea Act was amended as the Territorial Sea and Continuous Zone Act and the Exclusive Economic Zone Act was newly enacted. The fisheries agreement signed with Japan and China respectively in 1998 and year 2000 have also been supplemented with provisions that comply with the UNCLOS. The Act on the Exercise of Sovereign Right on Foreigners Fishing within the Exclusive Economic Zone was also enacted in 1996, regulating the illegal fishing and the management of foreign fishing activities within the ambit of the UNCLOS. The Marine Scientific Research Act was enacted in 1995 prior to ratifying the UNCLOS, accommodating the provisions of UNCLOS regarding MSR, Marine Scientific Research. Other legislation, such as the Marine Environment Management Act, were either newly enacted or amended in compliance with the Convention.